3, 2, 1, ready, start. It is only on account of the observations made by this court in S. Vanitha versus Commissioner, Bengaluru Urban District that the tribunal under the Senior Citizens Act may also order eviction if it is necessary and expedient to ensure the protection of the senior citizens. Stop. The tribunal thus had acquired jurisdiction to pass orders of eviction while exercising jurisdiction under Section 23 of the Senior Citizen Act, which otherwise provide for treating the sale of the property to be void if it is against the interest of the senior citizen. Stop. Para. The aforesaid decision was followed by this court in Urmila Dikshit (Supra) stop. However, even in the aforesaid case, the court has only held that in a given case, the tribunal may order eviction, but it is not necessary and mandatory to pass an order of eviction in every case. Stop. The appellate tribunal has not recorded any reason necessitating the eviction of Krishna Kumar, or that in facts and circumstances of the case, it is expedient to order eviction so as to ensure the protection of the senior citizen. Stop. In our opinion, the appellate tribunal was therefore not justified in ordering for his eviction merely for the reason that the property belongs to Kallumal, completely ignoring the fact that the claim of Krishna Kumar regarding 1/6 share and the cancellation of gifts and sale deeds is pending adjudication before the civil court. Stop. Para. In our opinion, in the facts and circumstances of the case, there was no necessity for the extreme step for ordering the eviction of Krishna Kumar from a portion of the house. Rather, the purpose could have been served by ordering maintenance as provided under Section 4/5 of the Senior Citizens Act, and by restraining him from harassing the parents and interfering in their day-to-day life. Stop. Para. In the light of the above situation, the High Court appears to be well within its jurisdiction to set aside the eviction order passed by the tribunal and to maintain the other conditions imposed by the tribunal. Stop. The apex court noticed that the maintenance tribunal / appellate tribunal does not have the power to order eviction, and this decision also referred to the observations of the apex court in Urmila Dikshit (Supra) stop. Thereafter, another decision of the apex court came in Rajeshwar Prasad Rao versus State of Bihar 2025 Live Law (SC) 418, where the right to issue an order of eviction in certain circumstances has been recognized, and the relevant portion reads as under. As far as the authority of tribunal under the Act to order eviction is concerned, this court in S. Vanitha versus Deputy Commissioner Bengaluru Urban and others, specifically held that the tribunal under the Act has the authority to order eviction to ensure the maintenance and protection of the senior citizens. This case involved a similar challenge to the order of eviction by daughter-in-law. The relevant paragraph para 25 from the case is extracted below. The substance of subsection 2 of section 23, as submitted by the second and third respondents, is that the tribunal had the jurisdiction to pass an order directing the eviction for 2021 15 SCC 730 SLP civil number 7675/2024 page 10 of 12 of the appellant, who is their daughter-in-law. According to the submission, the power to order eviction is implicit in the provision guaranteeing a right to receive maintenance out of an estate and the enforcement of that right. In supporting the submission, they have referred to the view which has been taken by several high courts, indicating that the tribunal may order the eviction of a child or a relative from the property of a senior citizen, where there has been a breach of the obligation to maintain the senior citizen. The tribunal under the Senior Citizens Act, 2007 may have the authority to order an eviction, if it is necessary and expedient to ensure the maintenance and protection of the senior citizen or parent. Eviction, in other words, would be an incident of the enforcement of the right to maintenance and protection. However, this remedy can be granted only after adverting to the competing claims in the dispute. It is necessary to recapitulate that the situation in the present case is that the eviction was sought of the daughter-in-law, that is, the appellant. The land where the house has been constructed, was originally purchased by the son of the applicants who are seeking eviction of their daughter-in-law. The son had purchased the property a few months before his marriage to the appellant. He had subsequently transferred the property by a registered sale deed to his father, and the fact that it was for the same consideration after the lapse of several years is of significance. The father, in SLP civil number 7675/2024 page 11 of 12 term, executed a gift deed